I sat down the other day with Wendy Mara, an attorney in Ormond Beach, Florida. Her practice areas include estate and trust planning. Let's go to my interview with Wendy for a discussion of these very important topics.
If you are moving to Florida from another state, and I see this quite a bit in my practice, you do want to make sure that you have an attorney review your documents to make sure that whatever documents that you have are going to work well for you in the state of Florida. So that is important, that seeing as you brought that up, I figured I'd throw that in there.
Good.
The basic documents that you're looking at when you are doing your estate planning, either a will or a trust, or it may be both. If you have a trust, you want to pour over wills so that anything you forgot to put into a trust is poured into it in the event, at the point where you are deceased. And those take care of your things, and a durable power of attorney takes care of your things so that somebody can make financial decisions for you if you are unable to, or you just don't want to anymore. It's not just if you are incapacitated. So those take care of your things. The other documents, which to me are very important, are those documents that take care of your person.
Your person.
And so basic healthcare surrogate, if you are incapacitated and unable to make healthcare decisions, you want to appoint somebody who is going to make the same decisions you would make. So it's important you choose carefully. You choose somebody who you know is going to honor your wishes. The most recent healthcare surrogate forms also allow for somebody to make healthcare decisions while you still have capacity. And there are some older people who go to the doctors and they're overwhelmed with everything the doctor tells them and don't want to make those decisions. They're unsure of those decisions. So some people will allow somebody to make decisions even when they are not incapacitated, but that's a little rare. HIPAA releases so that people can obtain your health care information is very important. I also do a pre-need guardian.
This is the key one I want to make sure we can talk about,
I know that not all attorneys do that in estate planning. Maybe it's because I practice in the area of guardianship that I see this as a very important document. But a pre-need guardian is when a person is able to choose in advance who they would like to serve as their guardian in the event that person becomes incapacitated.
So what does a guardian do?
Okay, a guardian, there are actually different types of guardianships, first of all. There's your regular guardianship that most people think of when somebody becomes older, becomes incapacitated to dementia, or maybe even a car accident, something like that. So that's sort of a straightforward guardianship, and I'll talk about that. A guardian advocate is specifically designed for somebody who is born with developmental disabilities. So that person has to have a certain, the statute prescribes what exact types of disabilities they have to have. For example, Down syndrome, some sort of intellectual disabilities, Willie-Prater syndrome, which I don't think is as, people aren't as familiar with that. Cerebral palsy, autism. So those are some of the particular, and it has to fall within that statute. And it has to manifest itself before the age of 18, and it has to be enough of a disability where the person's not able to take care of himself or herself. That's a different type of guardianship, and the process is a little bit different because there's no need to, for the court to find that the person is incapacitated.
So if somebody finds they need these things, either because of somebody being born with certain developmental issues, or somebody's older and they no longer have capacity, they no longer are competent, then what has to happen? You need these documents beforehand? You can get them later?
Right. Well, the pre-need guardian must be signed when somebody has capacity. So somebody with a developmental disability probably
never really
doesn't
have
have
that capacity.
And most often it's a parent who's going to be the guardian of a developmentally disabled person.
And the courts would recognize that.
Exactly. So that document is only going to be useful if somebody signs it when that person has capacity.